Good afternoon, everyone, and welcome to the webinar, Protecting Temporary Protected Status, Beneficiaries, and Your Business. We are so glad you could join us today. I'm Daryl Maxwell, Managing Attorney for the DC Bar Pro Bono Center's Nonprofit and Small Business Legal Assistance Programs.
And I'm Adrienne Gottschall, Managing Attorney for the DC Bar Pro Bono Center and Overseer of the Pro Bono Center's Immigration Advice and Referral Clinic. To start things off today, we want to thank Susan Kern and Steve Patterson of Hunton Andrews Kurth LLP for kindly taking the time to present this webinar today. Susan Kern is counsel at Hunton, where she represents businesses and individuals in administrative proceedings before the U.S. Citizenship and Immigration Services, U.S. Customs and Border Protection, U.S. Department of Labor, and the U.S. Department of State.
Steve Patterson, a partner at Hunton, is the co-head of the firm's Corporate Finance and Mergers and Acquisitions Group and the firm's Retail and Consumer Products Industry Group. His practice focuses on public and private securities offerings, securities compliance, mergers and acquisitions, and corporate governance matters for domestic and international clients.
And perhaps most important, or at least we like to think so, is Steve and Susan's commitment to pro bono service. Susan devotes more than 100 hours annually to pro bono work through direct representation and mentoring of other attorneys. She's also one of the DC Bar Pro Bono Center's longest serving volunteer mentors at our Immigration Advice and Referral Clinic.
And Steve has been a longtime volunteer and advocate for the DC Bar Pro Bono Center's Small Business Brief Advice legal clinics. Today's webinar will focus on the following topics. Susan will cover an overview of temporary protected status, or TPS, including terminations and extension dates, other potential avenues that TPS beneficiaries can explore to remain in the U.S., and under what circumstances an employer may sponsor an employee. Then we will switch gears over to Steve, and Steve will cover the options available to TPS beneficiaries who own businesses.
It's important to remember that this webinar will cover information only, and it is not intended to be legal advice. It may be important for you to check the laws in your jurisdiction and consult with a local attorney regarding your matter.
Just wanted to quickly go over some logistics for today. If you're interested in following the PowerPoint on your own or printing it out, there is a copy of the PowerPoint in the handout section here on GoToWebinar. You'll find it right above, right in the control panel, right below questions. Also, if you have questions for the webinar, we will be reviewing them and passing them along to our presenters. Please make sure to put your question in, and we will get to them as quickly and as well as we can. Just also to let you know, this webinar should go for approximately an hour. We've sort of budgeted a little extra time in case there are additional questions.
All right, and with that, we're going to turn it over to Susan Kern to begin today's webinar.
Hi, everyone. Thank you so much for joining us, and thanks to the DC Bar Pro Bono Center for inviting us to participate in this webinar about this very important, very timely topic. I am going to discuss, as Daryl mentioned, a very high-level overview of potential immigration options for people whose TPS has been or is being or will be terminated. And first, let's just talk a little bit about what is temporary protected status for those of you who may not be familiar with the term. This is, strictly speaking, even though the term itself contains the word status, it is actually not a status technically under immigration law. What it is an executive action, essentially deferred prosecution for potential removal. So what happens is, for countries where conditions prevent the safe return of those citizens to their countries, if they should be in removal proceedings in the United States, because of environmental disasters, armed conflict, or certain other types of conditions, the executive branch, knowing that it cannot actually remove these people to their home countries, puts them in a form of deferred action and called temporary protected status. This status can be designated for countries for only a period of 2 years, or it can be renewed in increments of 2 years, sometimes for a very long time, including for a couple of the nationalities who are currently being terminated, whose TPS status has been active for decades. If you get temporary protected status, you cannot be detained or deported. So it is a protected status, but it is temporary. And because it's a creature of the executive branch, it can be terminated or revoked by the executive branch essentially at will. And that's what we're seeing. Temporary protected status does not lead to a green card, but it does allow you, if you qualify in some other way for a green card or potentially for another form of temporary status, it doesn't prevent you from acquiring that status, although there are some limitations to that we will talk about. So your TPS is terminated or will be soon. What happens from one day to the next when your TPS is terminated? First of all, I think it's really important for people to understand that nothing automatically happens. Nobody automatically shows up at your door, knocks on your door, and takes you away. That simply doesn't happen. There are hundreds of thousands of people in the U.S. who have temporary protected status. They are not going to all be rounded up and put into removal proceedings. So it is very, very important that before TPS is terminated, everybody who has TPS gets a very thorough screening by a competent immigration attorney or nonprofit legal service agency that provides immigration legal services to see if you might potentially be eligible for some other form of status that you could transition into either now or when your TPS is finally terminated. And as part of that screening, it's extraordinarily important to check for any red flags. There are obviously people who have, for example, certain kinds of criminal convictions or certain kinds of serious immigration violations could already be on the radar for the government, for ICE. And those people could potentially face some sort of removal action after their TPS is terminated. They are protected until their TPS is terminated. So it is very important to get a screening to ensure that those red flags, either you don't have them, or if you do, how potentially to protect yourself or to be aware of that. So are there any other options for people whose TPS is being terminated? We're going to cover each of these categories briefly, but this is the list of potential avenues of other forms of relief for people who no longer have TPS. There are a couple of non-immigrant categories. The word non-immigrant simply means a temporary form of status, but this is actual non-immigrant status. And if you actually hold non-immigrant status, then potentially that could lead to a green card in certain ways. There is sponsorship for a green card by either a family member or an employer. There are various forms of humanitarian relief that people may be eligible for, such as asylum, status under either the U or the T visa categories. These are folks who help law enforcement and who are themselves victims of certain kinds of crime. And under potentially, if you qualify with a qualifying family member and you have been abused or battered or subjected to forms of extreme cruelty by that family member, you could qualify for a green card under the Violence Against Women Act. And then there's special immigrant juvenile status. Now, each of these categories, of course, has some very strict rules. There are some benefits under NICARA that we will discuss very, very briefly. And if you are in removal proceedings or land in removal proceedings, there are a couple of forms of relief there as well. So let's talk about the non-immigrant categories. some people potentially can go back to school as F1 students. F1 students can't automatically work, so anyone who has TPS has a work permit and has probably been working for a very long time. And of course, the main concern will be, how can I continue working? If I own a business, how can I continue running my business? Which Steve will talk about in much more detail later after me. But potentially, you can go back to school as an F1 student. You have to prove that you're not going to work without authorization, and therefore you have money to pay for all your student expenses. However, work is allowed at certain points during your career as an F1 student. You can work on campus after a year. You can also work off campus if it's part of your program, for example, a master's degree program. And some bachelor's degree programs have practical experience components. And you're also eligible to apply for a one-year work permit after you graduate, which can sometimes be extended if you graduate in STEM fields. And by the way, if you're following along on the handout, this is a late-breaking last-minute slide, which is not in the handout. Another conceivable option is the H-1B category. The H-1B is a work-authorized visa. However, it is very, very restrictive. You have to have a sponsoring employer. That employer has to pay the prevailing wage, and the job itself has to be at a level that requires at least a related bachelor's degree. And perhaps the highest hurdle there is that H-1Bs are limited every year. You can only file for them 5 days per year, and because the demand so far exceeds the supply, there's only a 50% chance of winning the chance to have your petition reviewed in the lottery that the Immigration Service runs for these on an annual basis. So that is not going to be an option for most people. And then finally, in the non-immigrant category, there's also a visa called O1, Extraordinary Ability. Again, this is very difficult standard to meet, but someone who has extraordinary achievements in the field of business, for example, might be able to qualify. So let's talk about green cards now. What family members can sponsor you for a green card? There you have it. Those are the relatives who are able to sponsor people. An adult U.S. citizen can file for a parent, a spouse, a single child under age 21. Those three categories are called immediate relatives. There's no waiting list for a green card number for them. There are always green card numbers available. And an adult U.S. citizen can file also for a single child over age 21, for a married child of any age, and for a sibling. But in those categories, there's a tremendously long wait list that doesn't provide any way to live or work in the country for many, many years. If you have a relative who has a green card, who is not a U.S. citizen, the categories are even more restricted. Green card holders can file for their spouses and single children. That's it. And there are wait lists in those categories. If there's a wait list for a green card number, then there's no way to live or work in the U.S. while that process goes on. There are 2 steps that are listed there for the family-based sponsorship processes. At step 1 is just your relative filing for you. That doesn't give you any right to live or work here. It's only at step 2, when the green card number becomes available, that you actually have the ability, the lawful presence, and the ability to work in the U.S. What about employers? Essentially, the steps are the same, more or less. However, there's an additional step that almost all employers have to go through, and that is step 1 with the U.S. Department of Labor. That is a very, very difficult step. If you are the owner of your own business, you cannot sponsor yourself for a green card. It has to be a job that's available to any U.S. worker. However, many people who have been working on TPS with employers for a long time could potentially be sponsored. You have to get, however, to step 3 before you have the ability to live and work in the U.S. Just like on the family side, On the employer side, there are limited numbers of green cards available in virtually all categories, although there is actually a limited number in every category, but sometimes the demand in that category for that nationality is not that high, so green card numbers are always available. There is actually no wait list in any green card category right now at last check for any of the countries whose TPS is being terminated. So that means that if you have an employer who's willing to sponsor you and who's willing to go through these steps, potentially over the next year or two, you might actually qualify to file for a green card, get to that step 3, and be able to file for a green card before your TPS is terminated. But let's talk a little bit more about that final step. So this slide discusses both what you have to do, what the bars are to being able to file that final step of a green card process, and also to be able to change status to one of the non-immigrant categories we talked about without leaving the U.S., such as F1, H1B, or O1. You cannot do those things unless you are eligible to do so. It's considered a privilege and a benefit to be able to remain in the U.S., maintain your current status while you change to another one, or while you adjust status to permanent residence and get your green card. So there are limitations as to who can do that. You are ineligible to do that if you entered illegally, and this is the case for many, not all, but for many people who have TPS. If you entered illegally, unless you live in the states that are listed there, and like the fourth or fifth line down, you are not eligible to file to adjust your status to permanent residence based on employer or family sponsorship unless you live in one of those states. And that's because of certain court decisions that have come out in the 6th and 9th circuits considering TPS to be a valid entry, quote unquote. If you don't live in one of those states, you are not eligible to file for adjustment of status unless you have maintained your status throughout and have not entered the U.S. illegally. There are other ways that you can be ineligible to file for adjustment: criminal issues, public health grounds, good moral character issues, and a number of other issues. So if you do not apply, if you're not eligible to apply for your green card in the U.S., is there an alternative? Yes, there is. You can leave the U.S. and complete the green card process by filing for an immigrant visa at a U.S. consulate in your home country. However, when you leave, if you have been unlawfully present in the U.S. for certain periods of time, you will trigger a bar to returning to the U.S. And those time periods are listed there on this slide. If you've been unlawfully present 180 days up to just short of a year, and you leave, you trigger a 3-year bar. If you have been present for a year or more unlawfully, then you trigger a 10-year bar to returning. And so you can see that the ability to apply for adjustment of status without leaving the U.S. is very important for people who do have unlawful presence. If, however, you have less than 180 days of unlawful presence, then you do not trigger those bars if you have to leave, if you're not eligible to file for adjustment of status in the U.S. It's also important to point out that any time that you have spent with a valid TPS application on file, pending with the Immigration Service, and all time you've spent with TPS status does not count as unlawful presence. So here again, you can see the importance of having a very good screening by very good legal professionals to ensure that the math is done correctly and that you know exactly what you are and are not eligible for. There are some waivers of these unlawful presence bars, but they require proof of extreme hardship to a spouse or parent who is a U.S. citizen or lawful permanent resident. And you'll notice right away that child is not included in that list of qualifying relatives for a waiver of the unlawful presence bar. That was quite intentional on the part of the lawmakers who wrote this law.
And Susan, we do have a question from the audience regarding family sponsorship. So with regard to family sponsorship, is there a limit to how many eligible relatives one can file for?
There's no absolute limit. However, you do have to be able to show that you can support each person that you file for at least 125% of the poverty income guidelines, and these are published every year by the Department of Health and Human Services. Just to give you a general idea, right now for a family of 4, the poverty income level is, I believe it's around $24,000. So 125% of that, just slightly above that, is the poverty income guideline for a family of 4. So each person who a U.S. citizen or permanent resident files to sponsor, is one additional member of the household, and they have to be able to show the requisite income level for the full household. There is also a possibility of getting joint sponsors to file jointly with you and say that they will make their funds and resources available for the household as well.
Thank you.
You're welcome. Okay, so let's talk about some of the avenues of what we call humanitarian relief. This is called humanitarian relief because it is not quite as strict or as inflexible as some of the employer and family-based and non-immigrant sponsorship categories. For example, many people who are losing their TPS will be able to file claims for asylum because they either have already suffered persecution in their home countries before coming to the U.S., or they have a legitimate or reasonable fear of suffering persecution if they return to their home countries. The persecution has to be on one of the protected grounds that are listed here. And of course, there's an expansive legal definition for each one of these grounds. And the biggest hurdle is you are not eligible to file for asylum unless you file within 1 year of arriving in the U.S. There's an exception if there were extraordinary circumstances that prevented you from filing within that 1 year, or that made it unnecessary for you to file. And having valid status, including temporary protected status, is one of those extraordinary circumstances. You're not afraid to return to your home country if you have TPS because you know you're protected from that. However, if you waited more than a year before applying for TPS after you got here, potentially you don't meet that 1 year deadline. Again, these are very fact-based scenarios. It's really important to get screened by a competent professional. And in addition, since TPS is being terminated, the administration for all of these countries, the administration has also changed the way it's doing asylum cases. It used to be that it was the logical way, first in, first out. That has changed now. It's last in, first out. And I believe that the administration changed this because they know that there will be a very, very large influx, tens of thousands, if not more, people who are losing their TPS who are now filing for asylum. And there is the ability to get a work permit at a certain point. If your asylum application has been pending for a certain amount of time and has not yet been processed, you're eligible to apply for a work permit. I believe that the administration has changed the order of processing so that it does not have to issue work permits to all those people. So now, once you file, in most places around the country, if you file for asylum, you're going to be interviewed. You're going to have your asylum interview within just a matter of a few weeks after filing. And you're either going to be approved at the interview or you're going to be referred into removal proceedings. So again, very important to have somebody review your case in great depth to ensure that you have a bona fide asylum claim. You can no longer kind of just sit back and collect your work permit and wait years before you're actually interviewed. That is not happening anymore for people who are filing now. Then there is also U and T status. U and T status, although these are humanitarian forms of relief, they are also actually non-immigrant statuses that lead directly to a green card. After you hold U status or T status for a period of 3 years, you can apply for a green card. You don't need any other sponsorship. So if you have been the victim of a crime and you've been helpful to law enforcement, it's very important that you have somebody look at that situation and see if you may be eligible for a U. If you were trafficked, and there are certain definitions of what trafficking is, you may be eligible for a T visa as well. And finally, under the Violence Against Women Act, this category follows the exact same family-based relatives that we saw in that slide. In other words, you still have to have that qualifying family member. It still has to be one of those people. The adult U.S. citizens or somebody with a green card can only sponsor in those categories that we saw before. However, if you do have a qualifying relative like that, and that relative has abused you or has, and it doesn't actually have to be physical, the standard there is extreme cruelty, and that can be psychological as well as physical. If that's the case, then you are eligible to sponsor yourself. You still have to show that qualifying family relationship, but you can file your own petition and you don't have to have that relative's participation or signature or even knowledge. And this is a very, very important category for so many people, particularly the victims of domestic violence, because it enables them to be independent from their abusers, to get a temporary work permit, and ultimately to get a green card whenever the normal family-based categories would allow them to. You can even, and this is not the case with the normal family-based categories, but because this is a more liberal humanitarian version of the family-based categories, if you divorced your abusive spouse within the last 2 years, or if your abusive spouse died within the last 2 years, you are still eligible to file, to self-petition under the Violence Against Women Act.
Now, Susan, we have a question from the audience regarding asylum. You mentioned that there is a 1-year deadline after arrival in the United States unless there's extraordinary circumstances. And as many of us know, some members of the immigrant community have certain cultural beliefs or maybe levels of discomfort regarding law enforcement for a number of reasons. To the best of your knowledge, are you familiar with any case law or other policy or practice? Has that ever been considered, those cultural beliefs, to be extraordinary circumstances to help someone get around that 1-year deadline?
In other words, somebody being afraid to actually step forward and apply for asylum because of fear of authority. Was that the question?
I believe so, yes. I believe that would be one example maybe of a cultural belief regarding law enforcement. Maybe that they wouldn't be treated appropriately or fairly, or there would be truly a fear of coming forward and seeking that help.
I personally am not aware of circumstances like that being considered to be extraordinary circumstances to get around the 1-year deadline. But I don't have a very large asylum practice. It's possible that there is a case or one or more cases out there that have looked at this issue. I'd be happy to look at that and report back later.
All right. Well, thank you, Susan.
You're welcome. So this final version of humanitarian relief is really a very narrow one because it's only for minors. You have to be under age 21 in most states. This is kind of a hybrid of state law and federal law. In some states, you actually have to be under 18. However, if you meet the requirements in your state, the age requirements, and you've been abused, abandoned, or neglected by just one parent or both parents, and you're unmarried throughout the process. Marriage invalidates you as a juvenile, but if you remain single, if you meet the age requirements, and if you've been abused, abandoned, or neglected, and a state court issues an order making you a dependent of the court or put you in the custody of an agency or an individual appointed by the court, then you are eligible to file with the Immigration Service after that order has been issued for a green card as a special immigrant juvenile. There is a cap on the number of these that can be issued every year, as is the case with many categories. However, you're still allowed to remain here and you get a work permit while you're waiting to complete the green card process. And this is applicable even if you entered without inspection, which is the technical term for entering illegally. That does not prevent you from getting special immigrant juvenile status. So there may be some people who can qualify in this category. We're really not going to talk too much about these. The Nicaraguan and Central American Relief Act, the only country out of the countries that are being terminated for TPS that's eligible under NICARA are Salvadorans, and you have to have been in the U.S. since 1990. It's a long time, but some people may actually qualify. There are a number of other very complicated requirements, multiple deadlines to meet, but I have seen people, in fact, at the DC Bar Immigration Clinic a time or two, who actually do meet these requirements and had no idea that they were eligible for NICARA. So this is important to review with somebody who can look at your entire background. And this is a direct route to a green card. And finally, if you do land in removal proceedings, and you have 10 years of continuous physical presence in the U.S., as well as good moral character, you may be able to have your removal proceedings canceled and be awarded a green card by the judge. So some people, this is not, you can't proactively apply for cancellation of removal. You have to actually be in removal proceedings in immigration court and make that application or that claim before an immigration judge. And then there are other ways to just be temporarily relieved from removal. You hear about these folks in the news a lot. These are people who perhaps have what's called an order of supervision. What that means is they already have a removal order, a final removal order that can be executed at any time, but they've been put into another form of deferred action similar to TPS, where they are able to remain in the U.S. for various reasons and apply for work permit, but they have to check in on a periodic and regular basis with ICE, and ICE can at any time revoke that order of supervision and initiate removal proceedings. And we're seeing this happen very frequently now, and there are a lot of news reports about this. The reasons that ICE may put someone into this sort of temporary relief from removal could potentially be for health reasons, because there are very small children in the family, because the person is pregnant, or for other reasons. But this is really just a form of prosecutorial discretion. It's not permanent by any means. It's actually quite tenuous and can be revoked pretty much at any time. And that's all I have on my end.
All right, thank you so much, Susan. So we received a couple questions during your portion, and I have one last question for you regarding the F1 student status. Since this individual must prove that they will not work without authorization and that they can financially support themselves when they're on the F1 status, do you happen to know whether they're eligible for student loans that many other students would be eligible for? And I understand this isn't your normal practice area, but to the extent that you have knowledge of that.
We actually do see the F1 students quite a bit, so I do have knowledge of that. And unfortunately, no. Foreign students are not eligible for any form of government loan in the U.S. at any level. It's possible that they may be eligible for some scholarship assistance, merit-based, potentially need-based, but they cannot apply for student loans the way that permanent residents and U.S. citizens can. Foreign students are supposed to be able to prove that they have independent funds through family members or whatever, legal funds to support themselves throughout their college career.
Okay. Certainly limits the pool, certainly, but thank you for that clarifying that. One last question just came in. From an advocate's perspective, has mobile technology affected the process at all? And if so, how?
Okay, I'm going to assume that means mobile technology, meaning the ability to file things electronically. I'm not sure I understand that question.
It might also, that and also maybe to navigate different service providers and to know your rights. Let me see if we have any more clarification coming in. You know what, let's come back to that one. Another question that I have for the H-1 visa lottery, when does the lottery occur and how long does a person have to wait to see if they've been picked?
The H-1 lottery, the 5 days of filing are always the first 5 business days in April. And it typically, it takes a couple of months. For example, we just finished a lottery just last month, and we are just now starting to get receipt notices trickling in for the petitions that were selected. However, the administration published in its regulatory agenda for this coming year a new rule that will change how the H-1B lottery is run. Previously, anyone could file a petition for any employer could file a petition for any number of H-1B workers, and they all go into a big pot, and the lottery is run on all of them. In the new rule, the proposal is that won't happen anymore. Instead, employers will have to pre-register and say, we want to file for XYZ and name the people they want to file for. And then a sort of a pre-lottery will be run on the employers and not on actual petitions. And then only those employers will be allowed to file the petitions. So we do anticipate that that will probably be the way it is next year.
All right. Well, Susan, we just want to thank you so much. One of our attendees, instead of writing a question in the question box, just wrote, excellent presentation. So we agree, and we thank you so much. What we're going to do now, we're going to turn things over to Steve, and Steve is going to talk about the business side of this all. So Steve, what information should business owners with TPS be considering right now?
Well, thank you, Adrienne, and thank you, Susan. And I'll add my 2 cents. That was excellent. Up to now, Susan's been discussing the impact of termination of temporary protected status on all individuals having that status, and so now we're going to narrow the discussion a little bit to address the impact of termination of temporary protected status on individuals who are business owners. And there's a fairly large number of people in that category. Over 1 in 10 people who have temporary protected status are owners of businesses, and so there are many people in this boat. The silver lining on all of this is that there is time to deal with, if you're a business owner, there is time to deal with termination of temporary protected status. On the slides, we show some of the termination dates for individuals from various countries having temporary protected status. The one coming up soonest is November 2nd, 2018, which is less than 6 months away. But even that is enough time to deal with the things that business owners thinking about as they are thinking about what to do if they are leaving the country. Termination of temporary protected status is actually complicated for everyone, but it's even more complicated for business owners because of all the things you've already got going on as a business owner. You've got your employees, you've got vendors, you've got customers, depending on the type of business you run. You've got regulatory issues that you're thinking about, and you may have regulatory relationships that go along with the requirements that your particular business is having to deal with. So what should business owners do now? I think the number one thing, just to alleviate some concerns, is that if you're a business owner and your temporary protected status is revoked, you're still a business owner, and you can still continue running your business as long as you're in country and termination date hasn't come along, or as long even after that, if you've set up your business to be run, for example, remotely. So the goal with this portion of our webinar is to help you who are business owners think ahead so that you can control the future of your business. Your basic options, and this is directly answering your question, Adrian, your options are: you can begin the process of selling or transferring your business to one or more other people, family members who may be past a temporary protected status, or friends, or other trusted advisors. That's number one, sell or transfer your business. Number two, you can begin the process of closing down your business, and that means selling your assets, taking care of your liabilities, distributing the proceeds to yourself. If you have other business owners with you, then distributing the proceeds to your co-shareholders. Number three is you can begin the process of thinking about how to operate your business remotely. If you'll be leaving the country and you know that, you can begin now setting up the business to be run by others. And you can still own the business, or you can transfer a portion of the
I think we may have lost Steve. So as we effort to try to get him back, I will try and go through a couple more things that business owners might want to consider. Certainly, if you're trying to sell or to transfer or to liquidate a business, if you decided that it's not sort of worth your time to try to hold on to the business, or sort of trying to sort of manage your status is difficult, you certainly want to consider sort of talking, and as Steve also mentioned just a little while ago, it can be a really difficult situation to try to find the right person, whether it be in your family or a business partner, but it's certainly worth considering to possibly to sell, particularly if you're, depending upon the work that you're doing, it may unfortunately kind of require you to find somebody, if you can't find somebody that you trust, or somebody who is going to be a good steward for your business, trying to sell the business might be a better option than maybe transferring it. It's also potentially, you may have to think about considering granting your power of attorney to another business owner. It can be a very difficult process, but it's certainly something that working with the right advisors, you can make decisions as to how your business will move forward. Another thing that you're going to want to consider is making sure that you have all of your business assets and liabilities. You want to make sure you have your paperwork and your facts in order. You want to know what your business bank account is and how it may have something, what your business bank account is going to be, where all that stuff can be found is certainly something that you're going to want to think about. Okay, and as we move to, forgive us for a second, we're going to move to the next slide in a moment. Thank you. So again, another thing that you're going to want to consider is in the event that your business has multiple owners, and I think we did touch on this a little bit before, you're going to want to obtain the proper approvals to try to appropriately sell the business if you need, or to transfer your assets. If you already are involved in contracting, and because there's such a high percentage of folks who have temporary protected status who are business owners, it's very likely that a lot of there are going to be contracts that you're involved in. You want to make sure at that point, you certainly want to make sure at that point that any of the parties that you're working with, if you're planning to transfer your assets to somebody else, or if you're looking to sell the business, that you are in touch with, you want to be in touch with any of those parties that you're working with. You want to make sure that your finances and accounting is in order as well. If you haven't worked with a technical assistance provider to make sure as a business owner that you understand the value of your company, that's really important, particularly when you've developed, you've determined how the valuation for sale. You want to make sure you have the right value and that you're not underselling your business or potentially trying to oversell your business and not getting a lot of takers. You certainly would want to consider using a business broker to help you find buyers. A lot of folks might think that's a bit of an expense, but it's certainly valuable and worthwhile, mainly for the fact that you may be able to find entree into different, and an ability to work with some different business owners.
Hey, Daryl, I'm back.
Welcome back. I was doing my best to try to hold on for you.
You were doing great.
Thank you. So I think we're going to turn the screen back over to you, and I'm on, I guess, slide number 15. So feel free to jump right in.
All right. On slide 15, I'll try not to repeat what you said, but if you're I think I went through the options before. Did you get those from me, Daryl? Just to be sure.
Yeah.
All right. Just to recap, the basic options for an owner of a business with temporary protected status who may be terminated is to begin the process of selling, transferring the business, begin closing down the business, begin the process of trying to operate the business remotely if you have to leave the country, or to do a variation of those things, to sell or transfer part of the business and close down part of it. So the first step is to decide the path you want to go down. If you are a seller of the business and you're a single owner, or all owners have temporary protected status, then you can consider selling the business to a third party. If you have multiple owners and some owners have temporary protected status that may be terminated, then you can sell to the owners who don't have temporary protected status. You can set up the non-temporary protected status owners to run or manage the business, or be your trusted managers if you need to leave the U.S. In any event, if you're a seller, you should consider having your business valued by a valuation expert. And if you're a seller of a business, then you should also consider using a broker who's in the business of finding buyers for businesses in your industry. Whether you sell or transfer, you should seek the advice of a tax professional who can tell you the most tax efficient way to handle your transaction. There are a couple of basic ways that business sales get done. One is the sale of all of the stock, or if it's an LLC, the limited liability company interests of the company, in which case the buyer is buying everything that is in the company. There's another way to sell a business, and that is to sell just the assets of the business. And that allows the buyer to get just the assets and certain liabilities that go along with the assets. There are two very different ways of structuring a transaction, and they have very different tax consequences. And so that is why you should talk to a tax professional about the structure of your sale. The sale of a business, if it's a stock sale, would involve a stock purchase agreement. If it's an asset sale, it's an asset purchase agreement. And those are, again, very standard ways of transferring a business to a third party. If you don't want to sell all the business, or the buyer only wants to buy part of the business, you can sell part of the business. You can follow the process that we just talked about of selling the assets of certain assets of the business to a third party purchaser, and the assets that aren't bought by the purchaser remain in your business, and you can follow the steps for closing down and winding up your business with respect to the assets and liabilities that remain in the business. You can also do a stock sale that involves a partial sale of the business. It just means you would have to move certain assets that you didn't want to be sold out of the company before you actually effectuated the sale of the stock. On the slide, you'll see that I reference the questions of whether if you're not selling all of the business, you can decide whether to sell a controlling interest or a minority interest in the business. And there are agreements that you can enter into with your purchaser regarding how the business should be run and what decisions you want to retain approval rights over. So the controlling versus non-controlling interest question also carries with it questions about who's going to have what rights to make decisions about the business. If your co-owner is in the U.S. and you're in El Salvador, you want to be able to you can do that. You'll just want to have agreements in place that allow for decision-making rights to be very clear between you and your co-owners. I've included a slide relating to buyer financing options, just as a way of reminding people that there are lots of different ways to accomplish the goal of selling the business. If you sell your business, depending on the circumstances, you may or may not have a sophisticated buyer or a buyer with convenient means to the cash to purchase your business. So seller financing is a possibility, depending on the trustworthiness of the buyer. Bank or credit union loans to the buyer are possible. Getting a home equity loan is a possibility for a buyer. Friends and family loans, credit cards. Nowadays, we also have crowdfunding sites that allow people to raise money and not have to file registration statements with the Securities and Exchange Commission, but to follow exemptions for crowdfunding that raise a little bit of money from a lot of people for certain causes. and back to the original method I mentioned, seller financing would involve a promissory note from the buyer to the seller, and I definitely recommend that you obtain counsel, legal counsel, if you engage in a transaction that has financial risk as a part of it that you, the seller of the business, would bear going forward. I had thought in putting this together that most people, building a business generally takes a long time, and people put a lot of effort into it, energy, financial resources. There's a lot of sweat and tears that go into building a business, and it's hard for people to think about turning that business loose. And so I have the option here to go through of operating a business remotely. And you can decide to operate the business remotely, either temporarily or permanently. And it may be a good option. I'm not sure you would want to permanently operate your business remotely, but it could be a good option if you have someone in the wings to take over the business, but they aren't able to yet. For example, a child or young adult who, or other minor relative, or even an adult friend or relative, or a business associate who's unable to take the reins now, but may be able to in 6 months or a year. You could set things up so that somebody's running the business for you, taking direction from you, providing information about the business to you, and to the extent possible, giving you access to information about the business, so that you can provide direction to a manager or a group of managers to run the business while you're unable to. The number one item here is to just have people you can trust on the ground to manage the business and who will stay in communication with you. You may ask, how is it possible for me to enforce my rights in the business if I own the stock, or I've got shareholder agreements with other people and they're required to do certain things and they breach those agreements? How can I enforce my rights to make sure that I'm ultimately protected? And that is a good thing about the U.S. Legal system and the U.S. court system, is that even assets can be owned by people in foreign countries, and you can hire counsel and other representatives to protect your interests here. The next slide I have, and the next and last slide I have, is a slide on closing down and liquidating the business. And this slide shows the general steps for winding up and liquidating a business. And the main points set forth here are that you would need to dispose of all of the assets one way or another, selling them, donating them, otherwise transferring them out, and hopefully raising cash in the process, and then paying off all of the liabilities. There are certain filings that should be made as you close down and wind up a business, and I'm short-circuiting a lot of them. This is just a very high-level overview, but the general approach is sell all your assets, pay off all your debts, and distribute the proceeds to the shareholders, yourself if you're the only shareholder, and then file whatever termination statement. Generally, there's one with tax authorities and one with the Secretary of State or State Corporation Commission or other corporate entity, agency of the state your business is either formed or organized under. You should also consider your approach to other aspects of terminating the business. For example, your approach to terminating employees. If you have more than 50 employees, you may need to follow certain notice requirements that are required by law. There's something called a WARN Act notice required generally when you have more than 50 employees at a location. You also may have employment agreements with employees, and you'd need to terminate those in accordance with the terms of those agreements. Those are the big ticket items in connection with closing down and liquidating a business. I have not talked about certain ways of other ways of disposing of a business, and the one that may be in the back of some of your minds is bankruptcy or liquidation through bankruptcy. There are a couple of different chapters of the bankruptcy code that you often hear about. One is a reorganization of your business, which doesn't really apply here, and the other is a total liquidation of the business, a process that you can go through if your debts exceed your assets and you want to wind up the business without having liabilities left over that you have to deal with. So I haven't put any slides in here about liquidation through the bankruptcy code, but know that that's an option if you're in a circumstance where you don't have anybody to sell the business to, you don't have anybody, family members to hand the business off to, you don't want to run the business remotely, and your liabilities exceed the assets of the business. That would be the situation to leverage the liquidation code of the bankruptcy laws. So that is an overview of the options for business owners having temporary protected status potentially terminated. And Daryl or Adrian, if you have questions, I'm happy to take those now.
Perfect. Thank you so much, Steve. So we've got, there's a question that, is there any, and this is probably going to be anecdotal data, but is there any data that provides insight to, the legal impact where contracts are concerned regarding termination of TPS? To your best knowledge, of course.
We haven't had any come across our desks here. We can imagine that, and actually in terms of, we draft a lot of agreements for business owners, some of whom are entrepreneurs or small business owners, and many of whom are larger businesses. And you can imagine a contract having a provision in it relating to force majeure, acts of God kinds of termination rights. But to my knowledge, I've never seen an agreement that had termination of TPS as a potential, as a provision potentially excusing or allowing for termination of an agreement. So generally speaking, it's the flip side of the principle that termination of temporary protected status doesn't end your rights as a business owner. You still have all the ability and rights to run your business as you do before. The only problem is that you may not be able to run it from the geographic location you want to. And so counterparties to commercial agreements would not generally agree to a termination of temporary protected status as a valid termination right under an agreement.
That's a good point. Thank you so much for that. I've got another question, and they're asking sort of from a governance perspective, if you have thoughts on sort of updating organizational policies with regard to, or how would you, or sort of thoughts about updating organizational policies with regard to remote operations?
If you're that question seems like it might be more directed to employees who have temporary protected status being terminated, but they want to continue working for the business. And I guess it's similar to the idea of working, teleworking. And plenty of businesses have policies relating to telework, but that wouldn't generally be a subject of a policy change. It's generally a one-off negotiation between an employee and an employer to be able to work. I know businesses in the U.S. who may be located in the D.C. area, but they've got a person who did work in D.C. and now they've been, for family reasons, moved to North Carolina, and they're permanently teleworking from North Carolina, and they're basically never on site at the company. My remarks are primarily focused on the business owner, and organizational policies don't generally need to be changed for the owner to provide direction to the company or to be able to work remotely himself or herself.
Daryl, this is Susan. May I just add a little immigration gloss on what Steve just mentioned about remote working employees?
Of course you can. Please go ahead.
Thank you. I find that among our clients, both company, for example, HR folks, and the employees themselves, there's confusion as to whether some sort of U.S. immigration status or U.S. employment authorization is required for people to work remotely from a location outside the U.S. for a U.S. company. And the answer is no. Immigration status and employment authorization are required only if you're working physically within U.S. territory. So if you're sitting at home in El Salvador or Haiti or India or wherever you might be, and you're working for a U.S. company remotely, you do not need U.S. employment authorization or any form of U.S. immigration status. Now, there may be other implications, tax implications, employer employment law implications, et cetera, corporate implications like Steve is mentioning, but that does not implicate U.S. immigration law. So I think it's important for people to know that they can work remotely from their own homes in their own countries without worrying about U.S. immigration status.
Thank you very much for that added nugget there. That was extremely helpful. So I think since we're pretty much out of questions, I think we're going to wrap it up. Please feel free, for all our listeners, feel free to virtually applaud Susan and Steve while we applaud from our office. Thank you so much, guys. We will. So what we're for those of you who are listening, what we are going to do next, you will hear from us. All of you who are on the phone, and then all of you who have registered, we will make sure to send out information about and a link so they can review and pass along the link to the webinar that we will put up on our Law Help site. Again, if you'd like to share any information, this webinar, with friends, you will be able to find it. We'll send you a link, but you'll be able to find it at www.lawhelp.org/DC/CED.
Also, if you are an individual affected by TPS, or if you have other immigration questions, or you know someone who does, we invite you to join us at our Saturday DC Bar Pro Bono Center Immigration Advice and Referral Clinic. All of the services we provide are free of charge, And our next clinic is going to be on Saturday, June 2nd at 10 a.m. at the wonderful Carlos Rosario International Charter School at 1100 Harvard Street Northwest in Washington, D.C.
Additionally, if you own a small business or you're considering starting one and need to consult with an attorney, please join us on May 23rd for our next clinic at DHCD headquarters at 1800 Martin Luther King Jr. Avenue Southeast. Thanks again, Susan, Steve, and Hutton Andrews Kurth for partnering with us. This was really fantastic. Thanks to all of you guys for paying attention and for giving us questions and your energy. We're so thankful. Have a wonderful day.